All right, so if everyone that's on here, if you don't mind dropping in the chat where you're dialing in from, where you're calling in from, we'd love to hear about where you're located. My name is Christian. I am part of the Chicago Graphic Design Club team, and I am based out of Oak Park. And if at any point during this event anyone has any questions about our organization, feel free to reach out to myself or Cheryl, and we'll be happy to answer any questions you have about ways to get involved and so on. So I'll do a little brief introduction about who we are as an organization. We're the Chicago Graphic Design Club. Our mission is to build a positive culture within the theory, craft, and practice of graphic design. We've been doing this for almost 6 years now. We start off as a very grassroots organization, and since then we've scaled our offerings and our programming to do events like these, to produce podcasts, to produce publications, to do a lot of stuff. So we have a seat for everyone at our table. So if anyone wants to get involved, whether as a participant or they want to contribute an idea or anything, our doors are always open. Some of our values and our mission is to create spaces of belonging. So spaces like these where people can come together to learn. We like to lead with purpose, and that means that we like to be intentional about what we do. And most importantly, we are all very much lovers of graphic design and anything design and creative. So through our platform, we celebrate design together as a community through conversations, through programming, through tours, and so forth. So this is kind of the core of us. Some of our programming includes studio tours. We do portfolio reviews. We're going to be doing a critique session in the next few weeks, TBD on that. And you can always find anything about what's happening with us through our social channels, Instagram, LinkedIn. We do have a newsletter as well, and you can find links to all of that on our website. We also do recurring social hours, we do book discussions, and we do a lot of stuff. We have one great event happening next month in February that we've yet to announce publicly, but it will be at One Design, and it's going to be a panel that's going to be talking about some very relevant topics that relate to design. We do have a publication called Faculty and a handful of other items available through our shop, and you're all encouraged to not just purchase our products, but also a lot of the products that we do have are created by members of our community. So if anyone ever wants to contribute a submission, let's say to our magazine, or has a product idea, again, our door is always open for that. Most recently, we did launch a new project called Point, and it is a newsprint publication that is devoted to typography. And unfortunately, these issues are only available in person. So if anyone is interested in purchasing one, they are $15. Just send us an email or send us a message through Instagram, and we can coordinate a time to either do a delivery or do a pickup, or you can just pick one up at our next in-person event. But these are really cool. These are limited to only 50 copies. So if you want to grab one, just know that we are selling these very quickly. So limited supplies. And then here's just another little preview. This zine in particular is about one font, and it's an interview with the font designer. So it's pretty neat. And it's printed on newsprint. It smells super good, and it's really, really big. Also, at the moment, we do have a call for designers available through our websites. We are partnering with another organization in Chicago called Aha Time, and we're asking designers to submit a poster that responds to a value of their choosing. And this is open to everyone. We are planning on doing some kind of in-person exhibition sometime in 2026. So you guys are all welcome to submit a poster. There's more details and instructions on how to get involved through our website. And our website we can put in the chat here, but it's just chicagographicdesign.club. We also have a podcast called Underscore, so you're all welcome to take a listen. It's conversations with a lot of creative people in Chicago, and I just recorded episode 99 right before this call, so we're about to reach episode 100, and it's a really fun, engaging podcast where we get to hear a lot of thoughts and perspectives from people in our community. And then here's just another little teaser of other items that we have in our shop. And if anyone wants to get involved, like I said, this is our URL. So with that said, I'm going to stop sharing my screen. There is going to be a period for Q&A towards the end of today's events. So if anyone has any questions, you're all welcome to put them in the chat or wait till the end to unmute yourself and just ask our speakers a question. So with that said, Cheryl, is there anything you want to add?
Nope, I think you covered everything.
Cool.
Thank you everyone for being here. We're super excited about this. We had a lot of registrants, so I think this is a very on-point topic right now. So with that, we're going to hand it over to Faye and Joe from the Irwin group, and they're going to tell us all about it.
Cool.
Let me share my screen. All right. And I will say making a PowerPoint for graphic designers is a lot of pressure because this is not my strong point, the design aspect of it. So just maybe squint a little bit so you don't see it too clearly. All right. So first of all, welcome everyone, and thank you so much to the Chicago Graphic Design Club for hosting us, and thank you to the rest of you for attending. We're very excited about this topic because it is, as Cheryl said, a very hot topic right now. And AI has kind of spread like wildfire in the last couple of years. And while there's a lot of conversation about it, it mostly centers around other subsets of AI, for example, environmental and ethical implications. And very rarely do we see conversations about the legal implications. So we're very happy to have this conversation today. And let's get started. Oh, there we go. So briefly on who we are, Irwin IP is a boutique firm, which means that it specializes in one area of law, which in our case is intellectual property. So helping clients resolve copyright, trademark, patent, and technology-driven disputes is kind of our strong suit. And we represent clients ranging from Fortune 500 companies to incredible startups and individual creatives. And while our focus has been IP for the past decade, we recently did merge with Miller Johnson, which is an incredible full-service firm, so that greatly expands the areas of law in which we now represent clients. And just so you know where we personally are coming from, quickly, my name is Faye Vasilopoulos. I'm an associate at the firm, mainly focusing on patent and copyright law, but I also have a small bit of experience in the creative AI side of work, because for a short period of time, I was working on a commission basis with authors and composers to create sort of promotional AI book trailers and music videos for them. So in that way, I'm a little bit familiar with some of the programs that we will discuss today. And I'll let Joe introduce himself.
Thanks, Faye. My name is Joe Marinelli, and I'm another Irwin IP attorney. Irwin IP is located in downtown Chicago on Wacker and Randolph. And I've been practicing for over 25 years. Most of my work has been in patent law, but I do some copyright work, and actually I really enjoy the copyright work because it is more human than patent law. So we're excited to be here today to talk with the club. The club has so many great things going on, approaching what looks like a 100th podcast for Underscore, which is really incredible. It's a little bit intimidating for us because we're here to speak on law, which can get dry. So we had told Cheryl that we were going to hold questions till the end. And no promises, and I haven't run this by Faye, I'm sorry. But if you do ask questions in the chat, and maybe when the other person isn't presenting, we might, if they're if they're going to be easily handled during the presentation, we'll try to do that to keep this a little more lively if we can. But if you want to hold your questions to the end or don't have any, that's fine too. So with that, I'm going to turn it over to Faye to kick off the presentation.
Right. So why do designers need to know and understand AI and copyright now? So each of you is bound to have a slightly different design workflow. So some of the following slides may be more relevant to you than others. But the common denominator here is that every single one of you in your daily work likely uses some extent of AI, even if you haven't realized it. So really understanding how this AI may actually be impacting whether your work is copyrightable or which parts of your work are copyrightable is very, very important. And especially for a profession like yours, where your clients likely expect exclusive ownership of the design that you create and that they pay for, this poses a challenge. And the challenge is that copyright law, as it stands, was built around a very sort of human-centered idea of creativity, and it hasn't fully caught up yet to the idea of a tool that is used for design, but also capable of adding its own creativity to the human's work. So our goal today is to translate the current law, unintuitive as it may be right now, into your practical workflows so that you can kind of walk away understanding, one, how to use AI-assisted technology in a way that doesn't stunt your ownership rights, and what portions of your AI-assisted work will have to be what we call disclaimed when you register your work. And with that, I will turn it back over to Joe, who will walk us through the copyright fundamentals, because understanding these basics is critical before we layer the AI on top.
That's right, Faye. So we won't get too heavy into the law, but it is good to have some background in copyright law because, spoiler alert, it's going to matter when it comes to what's protectable, especially for AI-generated works or combination human AI-generated works. So we start with what is a copyright? Well, there are various forms of intellectual property, and many people get them confused. We have patents that cover inventions. We're not talking about patents today. There's trademarks, which cover brands, Coke, Pepsi. There's trade secrets, which cover secret business information like customer lists or technical information. And then there's copyrights, which cover human generated works of authorship, like a book or a poem, movie, music, artwork. Those are all various forms of copyrights. And then what is a copyright? Copyright is an area of law, but it's also a form of property ownership. And there are a bundle of rights that come with a copyright. Now, there are criteria that you have to meet before a work of authorship qualifies as a copyright. And so first of all, the work of authorship has to be created by a human. And we'll talk about this a little bit later, but you can sort of see where I'm going with this, which is that if it's generated by a computer, by AI, it is not human generated. It can't qualify for a copyright. That's one criteria, created by a human. The second criteria is it has to be expressed in a tangible form, as opposed to being ephemeral or just a concept or idea. And then the third criteria is it has to reflect the author's creative choices and expressions. So it has to reflect some level of creativity. Those are the three requirements. And to dive in a little bit more, expressed in tangible form, what does that mean? Well, for example, a poem that you wrote down, that's expressed in tangible form. A song that was recorded on your iPhone or that you wrote the notes for in the music notations, that would be copyrightable, reduced to written form, or a drawing that you saved on your computer even. What's not fixed? Just an idea you had in your head, or a song you sang in the shower this morning, wasn't recorded, presumably. That's not fixed in tangible form. Or anything that hasn't been reduced to written form or saved on a computer or somehow recorded, it's not going to be copyrightable. And then the copyrights, as I said, that form of protection comes with a bundle of rights that are very valuable. That's why you want to obtain copyright protection. What are those rights? First of all, you get the exclusive right to reproduce the work. You get the right to distribute copies of the work. You get the right to create derivatives off that work, like adaptations or translations. You get the right to perform or display the work publicly. So if you wrote a song, you have the right to perform that song publicly. And then you have the right to license others to use your copyrights if you'd like to. And then to get a little deeper into the human creativity element, because that's going to be so critical to understanding whether a work of authorship that's generated using AI is protectable. The copyrights protect works of human authorship. So what is not protected? Like I said, the ideas themselves aren't protected. It has to be what's written down or recorded in tangible form. Copyright doesn't care how the effort that you put into creating the work. If you spent your entire life painting the ceiling of a chapel, or you threw a can of Benjamin Moore against the wall, copyright doesn't care how much effort you put into it. It doesn't cover a style or a vibe, and it can't cover things that aren't created by humans. So, for example, this photo on the slide is this picture of a monkey. And there was actually a case 6 or 8 years ago where there was an author, you might have heard of this case, a photographer gave his camera to a set of monkeys and had the monkeys set it up where the monkeys could take selfies. So this monkey was named Naruto and took a selfie of himself. And then PETA, as a friend of Naruto, tried to claim that Naruto had copyrights in this selfie because Naruto took the picture. And the California appellate court decided that the monkey wasn't a human, and therefore the monkey could not claim ownership in the selfie, even though the monkey took the picture. But for the fact that he was a crested macaque, he cannot own copyrights to this photo. And then how is a copyright obtained? Well, interestingly, unlike patents or even trademarks, copyright protection attaches automatically as soon as the work is fixed in tangible form. You don't have to run to the Copyright Office and register your copyright. You don't have to even tell anybody that you got a copyright. You don't have to get a registration number for the copyright. It's automatically protected as soon as you reduce it to tangible form. Now, as I said, registration with the U.S. Copyright Office isn't required, but we recommend it. And in fact, at Irwin IP, we do annual copyright clinics where we help people like you who are interested in registering for a copyright to register their copyrights with the U.S. Copyright Office. It's something you can do yourself. If you can file a tax return, a simple tax return, you can probably, with some assistance, file your own copyright registration. So we recommend that you do it. Why? Well, there's a few reasons. First of all, if you ever want to enforce your copyright against an infringer, you can sue in federal court, which has advantages to be in federal court rather than state court. You can get statutory damages under the copyright statute, which ranges from $750 per work to up to $30,000 per work, and anywhere in between. And you can recover attorney's fees if you do have to file a lawsuit to enforce your copyright. So there are these benefits that you get that come with federal registration that you don't get if you don't register your copyright. How long do they last? They last for a long time. Patents last for 20 years from the time you file a patent. Copyrights last for the author's lifetime plus 70 years. Or in the case of a corporation, if the corporation is the claimed author of the work, which can happen if the work was a work for hire, then it's 95 years from first publication or 120 years from the creation of the work, whichever comes earlier. So the copyrights have a long life, which is great. Now we're going to kind of roll into AI. And what is AI? I'm not qualified to, and we're not going to try to explain what AI is. But as we all know, it's a machine-based system that learns on vast amount of data. And then the AI, can either analyze the data and predict an outcome, or more and more as we use things like ChatGPT or other generative AI platforms, they take a step further, and they can generate an output based on your prompts, as we all know. And so generative AI is really what we're talking about today, because generative AI is the capability to generate a work. And there are a lot of different tools out there, and frankly, you probably are. You could flip it, Faye. Thanks. You're probably more familiar with these tools than Faye and I are, or at least than I am. And we're not going to try to be exhaustive, but we wanted to talk about a couple of these. A couple of years ago, we did a pretty good survey of the tools that were available, and that in the past 2 years, new tools have popped up. A lot of new tools have popped up, but here's what we're seeing out there. You can have core suites of graphics products, like Adobe Creative Cloud is an example, and you're probably familiar with that. Within Adobe Creative Cloud, it's a suite, is Adobe Firefly. And Adobe Firefly is an AI tool that you can use to edit and modify photos. You can fix backgrounds, like if you had a picture of a Chevy pickup in a forest, you could have it redo the background to be in front of the Grand Canyon. Adobe Firefly does that. Affinity Suite was recently purchased by Canva, which we'll talk about also. But Affinity Suite is a competitor of Adobe. Affinity Suite has a similar offering to Adobe, but right now, as far as I know, it's a little more limited in its native AI capability. But that, based on the fact that Canva purchased Affinity, and Canva is AI based, I think we can expect some changes in Affinity. It's often thought of as a more affordable alternative to Adobe. Now, if we move into user experience and user interface tools, we're talking about things like Figma and Canva. And Figma is a user experience, user interface tool that its sort of claim or niche is it can provide a collaborative platform where multiple designers can be working on a design with AI capability of generating layouts and even copy for designs. And then Canva, you might have seen ads for Canva. Maybe you're using Canva. If we were in a room, I'd ask, I'd have people raise their hands to see what tools they're using. But Canva is a popular tool for generating templates for companies with consistent themes throughout, and marketing designs. And it has it touts and claims to have a high capability of automatically generating this output. Then you have things like Midjourney, which now we're getting into kind of the core visual creation tools. Midjourney is a very powerful tool that can generate very high quality images and graphic art. It's prompt based, so it's kind of text to image based. You can also upload images to Midjourney and have it tweak them based on your prompts. There's a lot of, it gives the human input, the human controlling Midjourney a lot of control over tweaking the image. It's actually a very powerful and cool tool. Then you have things like Google Gemini. It powers something called Nano Banana, which is, again, Gemini powered. It's similar to Midjourney, and it's Google's sort of photo generation, image generation tool. And then Google has Veo, which is a video generation tool similar to ChatGPT's Sora. And as you know, ChatGPT can also generate images. And then you have very cool tools in the area of audio and voice generation, voiceovers. like 11 Labs will create very realistic text to speech voice cloning. You know, you can pick different voices, and it can create basically a voice script for text. And you have things like Suno. Suno will generate music. You prompt it. You prompt it with things like the genre, the beat. The more you put in, the more exacting output it'll give you. But it'll generate a song. And then you have things that are used for social media, like CapCut and Buffer. CapCut will automatically generate captions for a social media piece. And Buffer is a social media scheduling and management tool that will basically run social media for you and give you content and a cadence of when you should post. And it's very cool. Now, we'll get into this later. Sorry, Faye, you can flip the slide. We will get into this later, but these tools you have to know what tool you're using and what the terms and conditions are. And I think Faye is going to talk about that later, but it's very important for people who are using the tool because, for example, you may not, if you use a tool to generate copyright, you may not own the copyright. The platform might own the copyright. And sometimes it depends on whether it's the paid version versus the free version. So you have to you really have to be cognizant of when we're talking about copyrights, who owns the rights, whether it's you or the tool. In the end, we're talking about sort of two different categories. You have AI generated work where the AI determines the expression. And there may be then very little human input into what the outcome is. Or you can have AI assisted work, like I was talking with Midjourney, where you have the AI acts as a tool, but the human controls the AI and turns all the dials. And that's where you're getting into where you can have AI output that can be copyrighted. I think I'm turning it over to Faye now to talk about how does my use of AI impact the copyrightability of my work.
All right, so on a high level, the current rule is that there is no copyright protection for purely AI generated material, point blank, but this is for purely AI generated material. And so, for example, prompts alone do not provide sufficient control as of today's available technology. And again, if that doesn't make sense right at this second, it will in a little bit when we go through some more detailed slides. But on the But on the upside, copyright can cover human authored expression, perceptible in the output, creative selection and coordination and arrangement, and then any creative modifications that an artist does to the AI output. Okay. So it's easier to understand if we separate all types of AI creative works into three buckets in terms of copyrightability. So our first bucket is when AI is simply used in an assistive way. So if AI is used just as a tool to aid human expression and not generate the expressive content itself, then your work is copyrightable. So for example, this would include, say, on Procreate, when you are creating, say you're editing an image and you draw a certain line and your brush uses some sort of AI tool which creates a specific pattern without you having to actually draw out that pattern. That's considered assistive AI and has no impact whatsoever on your copyright. So that is still just part of your creative work and you don't have to worry about it. Now, bucket 2 below is when you combine generative AI and real human authorship. And this is the bucket that predominantly will apply to you guys, to designers, because, well, if you're using Gen AI. And this is when, and one second, I have all types of tech issues going on here. Okay, so here certain portions are protectable and certain portions are not. And the protectable portions will be the ones where even though AI generated a portion of your work, your creative expression still shows up in the final product. So, for example, when you use your creativity to sort of select, coordinate, and arrange different pieces of AI, but in a creative way. So, think of it kind of like creating a collage. Where certain elements might be AI generated, then that's okay. The overall selection of them is copyrightable. Or then if you take an AI generated image and you create manual edits, say on Procreate or what's another? I'm like so stuck on Procreate right now. You guys know the programs better than I do. When you do a manual digital drawing on it, for example, these substantial, or Photoshop, when you do these substantial edits on top of the AI generated image, then that makes it protectable. And then there are certain tools that let users control the placement and creative elements where those creative elements matter more than the actual prompt that you entered. And again, we will go more into that in the next slide. And then bucket 3 is just a pure text prompt to final output, which is just generally not protectable. And so, for example, if you are fully creating graphics on Nano Banana or Midjourney, and you're just entering a prompt and then it's giving you certain options for outputs and you're just picking one, that's generally not copyrightable as of now. So we're going to focus on bucket 2 because this one is the most complicated and the most relevant here. So the Copyright Office has basically said that when you are in bucket 2, which I'll reiterate is when you are when your work contains both human work and AI work, you have to kind of distinguish your AI use. So you have to ask yourself, is the level and type of AI I'm using in this work considered appreciable, which is another word for significant, or is it de minimis, which de minimis is a fancy word for minimal, like a minimal edit. And so if the AI portion of your work is appreciable, you can still copyright the overall work, but when you register your work, you will have to disclaim that portion of the work. So what this means is that there will be a section that says, is there any portion of your work that you need to disclaim? And you would basically just write out which aspects of your work are appreciable AI. So what is appreciable? The best test for determining if your work is appreciable is asking yourself, if this AI portion of my work had actually been created by a human, would that human be able to copyright just this portion by itself? So would this portion qualify for copyright, or would it be considered like a time, or would it be such an insubstantial edit that there would be no point to copywriting it by itself? So if it would stand on its own and be able to get copyrighted, but in your situation, it's created by AI, that means that it's substantial and you will have to disclaim it in your work. And it's important because if you fail to disclaim appreciable portions of AI, then the Copyright Office might just come out and say, okay, we just reject or cancel your copyright registration because too much of this is AI and you didn't disclaim which part was AI and which one wasn't, and we can't tell. So they're not going to sit there and pick apart. You will have to tell them. So examples include using AI to, for example, create a background, generate a text, as long as that text is copyrightable on its own. So for example, if you're just generating a caption or one snippet, since you wouldn't be able to copyright that tiny caption by itself, it's probably fine to just not include it because you wouldn't be able to get a copyright on it anyway. So it's not considered appreciable. So to make this make a little bit more sense, if you look over to the right this picture. So this is a picture from an Instagram digital artist who creates book content. And basically, according to the information they had posted, the background image is generated on Midjourney, but then the aircraft on the top is something that they created on top of the image on Photoshop and Procreate. So if they wanted to copyright this, would they be able to? Well, they would have to tell the Copyright Office, I want to copyright this image, but the background is an appreciable amount of AI. So the background I am disclaiming because that was generated fully on Midjourney. But then I added on top my own expressive content, my own expressive creation on Photoshop and Procreate by creating this aircraft here. So technically, they would be able to copyright the aircraft by itself and also the combination of the aircraft with the background. Because as you recall from an earlier slide, I know this sounds very complicated, and you might have to comb through these slides a couple times before it really kind of sticks. But combining this human created aircraft with the AI generated background makes the overall picture be considered almost like a collage, which can be copyrighted. Hopefully this kind of makes sense. Now for de minimis work, and it's the opposite of appreciable, so I'll be a little bit faster as I go through it. But basically, if it is present in your work, you do not need to disclaim it or even mention it to anyone. So for example, say this artist added some lines to the trees or with AI or made some minimal edits to this with AI, they don't need to mention that at all. So generating ideas. Oh, and this also goes with if you use, for example, ChatGPT in your ideation process to kind of come up with a concept which you then bring to life on manually. You don't have to disclaim this, or sharpening an image, making small edits, all of that is de minimis, so you don't have to mention it. Now, why I think this makes a little bit more sense if you understand why appreciable AI generated work is not copyrightable. And because a lot of people will say, well, my prompt was very creative. You know what I mean? I spent so long making it creative, adding the composition and the colors and even the lens that I want the image to portray. And the output is exactly what I wanted it to be. But the truth is, the Copyright Office says that the way that generative AI works right now is that it treats prompts kind of like instructions. So you can put in your prompt, which is your instruction, and it can be very specific. But then the AI program will inevitably also add in its own details. So there will almost be no circumstance where you type a prompt and there are no additional details in the final output that were, the AI's idea. So this kind of unpredictability is why the Copyright Office says, well, is this final output your expression, or is it kind of the AI's expression based on the idea that you gave it? And as you remember, what Joe discussed earlier, ideas themselves are not copyrightable. So the fact that this was your idea, and then the AI put your idea into a fixed, tangible form, does not make the output your tangible form. Complicated, but it will all tie in the end, hopefully. Yeah, so this lack of predictability essentially is the reason why appreciable AI portions have to be disclaimed. So we already touched a little bit on this, but I'll go through some common questions that you guys might be having. And as I mentioned earlier, some of these may be more relevant to some of you than to others, depending on how much AI you use in your work. Some of you might use only de minimis AI, while others may be using prompt-based AI. So bear with us. So the first question is if the prompt, well, we already went through this, but if the prompt is sufficiently detailed and creative, is the output copyrightable? And despite the amount of effort and creativity that may have gone into the prompt, the output is not in any circumstances copyrightable if it's just, like the raw AI output without your manual edits on top. And as we said, that's because AI systems can sort of add and omit their own elements without really getting your permission. So for example, to make that make more sense, on the left, I actually tried making my own example on Midjourney. I tried to put kind of a detailed prompt where I'm adding the lens, different details on the color grading. And I mean, the image was kind of what I had in mind when I entered the prompt. But at the end of the day, did I actually write in an intent for every single one of these details to show up? All the little windows, the rays of light. So as you can see, the AI does put in its own, it kind of fills in the gaps for you. Some more common questions. Is the prompt itself copyrightable? So the prompt itself could be copyrightable if it is so detailed that you could copyright it as a written work. And it has to be, sufficiently original. But even if that's the case for you, the output is not protectable. So only the written part will be protectable. So, if that's something you want to do, you can go ahead and do it. And then another question is, if my own copyrightable work is in the input, can I protect the output? So what this means is this. In some platforms, you can put your own work. So for example, I could take a picture with my digital camera of, say, my hand, and then I could put it as an omni reference into this AI platform. And then my hand, as it was in the picture, will show up in the output. So in the AI generated image, that input that I put, that was my own photography, will be copyrighted, will be copyrightable. So the reason I put these images on the left here is because this artist, I actually asked her about her work and she told me two things. She said, one, I make very detailed prompts, so shouldn't that mean that, I can copyright my work? And of course, I had to tell her that no, your prompt can be as long as you make it, but it's not going to make your output copyrightable. But then she also said that she takes really good care of using her own photography, putting all these omni references together on Midjourney, for example, and then creating output for fantasy photographs. That's like her niche. And so the images that she's created here are kind of collages of her own photography. So she can copyright them as collages and just disclaim the fact that they were generated on Midjourney. But then the overall output, again, would be copyrightable because of the portions that were her own. Then this one, I won't go too far into, but this was a pretty recent case and the first appellate case of its kind, so it's kind of noteworthy. But essentially, this artist, Thaler, he created an AI platform, which he then directed to create this image here that you see on the right. And he wanted to copyright it, but he listed the AI platform as the artist, which is important because I've heard some people asking, well, couldn't I use the AI the way that someone commissions work? So, for example, when you're commissioning a piece of work, you kind of give instructions to the artist and you say, I want a piece of work, I want to commission a piece of work that has this, this, and this. And the artist will then create that work for you, you pay for it, and then you have ownership. But you cannot do that same thing with the AI because, again, if you are commissioning an artist, the artist is a human who is authoring that work. If you are quote unquote commissioning an AI platform, it is not a human that can get copyrightability in that work. So all this case said was you cannot list an AI platform as the creator or as the author. If you do that, it will just flat out be rejected. They won't even look into it. So don't do that. So just to recap, so you have everything here together because it is a lot. The things that the AI generated and AI assisted portions of your work that can be copyrighted are one, de minimis contributions, tiny, small edits, small captions, things like that. You don't even have to worry about those. You don't have to disclaim them, don't have to mention them to anyone. Then if you take different AI generated graphics or AI generated, stock images, but you kind of coordinate and arrange them in a similar way that you would a collage, then you can copyright that selection. And I know it sounds abstract to say that you are copywriting a selection or coordination or arrangement, but the Copyright Office, I mean, you would still submit your total work as it is, and you would just say, I'm copywriting the selection, coordination, and arrangement. Then substantial human modification or editing. So say you generate an image of a generic woman, and then you really go into Photoshop and completely change everything about her, her face, her facial structure. You can protect, you can get copyright on the final image because it is so different than the raw AI image. And then there's two more. Human authored inputs that remain perceptible. As we said, if you use your own reference images, which then the AI platform kind of repeats and puts into your output, you can, of course, get copyright on those portions. And then AI used as an assistive tool, all the kind of generic tools like upscaling, grammar suggestions, you don't have to mention these anywhere, and they're completely copyrightable. So it may help. I'll go through these quickly so I can turn it over to Joe soon. But I'll go through just a couple of hypos so that it can help put things into perspective. And these hypos are actually straight from the Copyright Office, so you can fully trust them. So the first hypo, you type a prompt into an AI platform like Midjourney. You choose one of the outputs that matches, the exact vision you had. Is this copyrightable? And as we said, this is not copyrightable. Number two, and I want to note that the Copyright Office did say that as these platforms advance, this may change. So the way that Midjourney has been so far, most of the output is not copyrightable, but maybe now that there is Higgsfield and Nano Banana, where the outputs are, very, very, very accurate to your prompt, maybe we are getting closer to making this copyrightable. Don't know if this is a good or bad thing for creatives, but I'm just stating the facts. Hypo 2, you generate AI images and then you select, edit, crop, combine, and arrange them using your own design judgment. The selection and layout can be protected, but the underlying like AI elements that you used in the beginning are not. And then the last one I will skip because we kind of already went into this before. And I will turn it over to Joe.
So what do you do with all this? It as you can tell, it's a quagmire and it's a developing area of law. And Faye did a great job of showing you the possibilities. But we would love to be able to give you a playbook on how to preserve copyright rights in works that you create, maybe using an AI generative AI tool. And I think you can tell from what Faye taught us all, it comes down to really being able to distinguish your input apart from the AI's generative output. And because to get the copyright, you have to be able to do this disclaiming that Faye talked about. You have to disclaim what you didn't contribute as your human contribution. And that's tricky. It becomes very tricky, right? Because as we know, when we use these tools, when you use ChatGPT, you can find yourself down all sorts of rabbit holes. And it's very difficult to kind of back your way out and figure out how you got here, there from here, or here from there. So it's challenging, but like anything, I think you need to try to take meticulous notes. And I think a lot of these tools also have features that will allow you to track changes that happen to a design and where that change came from, what the prompt was that generated that change. Also, like for example, Faye was talking about, you might create a work using AI. For example, you might take a picture, a regular picture from a digital camera, and upload it to an AI. And have it put that picture into a collage. Your picture, as long as it's distinguishable and the output is copyrightable, it remains copyrightable. But you want to have a record of that picture as you haven't been the author of that picture apart from the AI. So it's going to take some effort to take meticulous notes to preserve the ability to distinguish your input from that of the AI. So we suggest things like saving your prompts and saving your generation attempts. We recommend screenshotting things if you can. And in the patent world, people keep inventors' notebooks where they write down all of the process, their inventive process, how they came up with the invention, experiments. You kind of do the same thing here in tracking all of your work. We also recommend that you, if you can, if you have the ability and bandwidth to write down some sentences explaining in plain English why you chose to use this prompt, or why you edited the result the AI came back with, and that's all going towards trying to distinguish what you contributed versus what the AI contributed, so that in the end, when you want to register your copyright, you can accurately disclaim what you need to disclaim. So that's the goal. We're not saying it's easy, but that is what you have to try to do. So when registering these marks, you can flip it, Faye. When you go to register the one more, yeah, there you go.
Wait. Oh, sorry. There we go.
Yeah, perfect. So when you register your mark, you're going to have to be able to describe the work as yours, as apart from AI, and you need to identify whether any part of it needs to be disclaimed because you didn't author it. So, like for example, and Faye touched on some of this, a lot of this actually. You could describe your work as a digital photograph of X. But it'd be better to say this is a layout, or this is an original illustration, or it's a selection or arrangement, like a collage Faye was talking about, of images. It's better if you can get more exacting in your description of what the work is, so that gives you the latitude to parse out your contributions and distinguish that from, and then be able to disclaim what AI generated as opposed to what you did. So keeping those meticulous records, like I talked about, will allow you to do this when you go and hopefully federally register your copyright. And then Faye's going to get into some risks and ethics and real world limitations of using these AI tools.
All right, so we already got into the fact that copyright law determines whether a right exists, but now say you've determined that, because as we said, if something is generated by AI, no one really can copyright that work. But if you have determined that something is sufficiently human authored that you can copyright it, You also need to really get into your terms and conditions of the softwares and platforms you're using, because some of them do have terms that say that, they keep a license of the generated material, of the AI generated material, or that if you end your subscription, they keep ownership, things like that, or that you can't use some of them commercially. So here we try to kind of create a summary um, from low risk to high risk. What low risk means is that generally whatever you create, no matter what it is yours to keep. And then high risk is kind of platforms where there is some sticky language where you need to make sure that you're okay with the platform retaining a license of your work. So the creative tools that use assistive AI, for example, Adobe, Affinity, Creative, Figma, and Buffer, these generally say that you keep control of your own work, so you don't have to worry. Then when it comes to Canva, the paid version of Midjourney, ChatGPT, Sora, and I think, yeah, Sora, Gemini, Veo, Nano Banana, CapCut, and I think it's also the paid version of Suno, but I must have forgotten to put it in there. Those are medium risk, so it means that you do own the work you create, but the platform might actually be retaining a license of your work to be able to use it either to train their AI or maybe theoretically to sell it. It's up to them. And then the free version of Midjourney, the free version of 11 Labs, and the free version of Suno all have language that says that they also retain significant rights to your work. And in some cases, you are not allowed to use the work you generate commercially. So if you are using this work commercially, just make sure that you do have the subscription. I think for most of these, it's $8 to $20 a month. So it might just be worth it for you to, get the paid subscription. And then this is more of just the same information. I won't pain you by reading through all of it, but in case any of you need to reference this and look at the specific platforms that you use, paid versus free, it tells you who owns the output, if you can use it commercially, what rights the platform retains, and if there is any IP ownership risk that you should look into. I don't want to leave too soon, but maybe I'll just skip to the next page, and then if someone at the end wants us to go back, we'll go back to it. So this is not so much legal related, but it is good to keep in mind the current ethical and potentially legal arguments that are out there right now as you're using this, because maybe your clients will care and whatnot. But one, the concept of style dilution is big. Essentially, that the more that AI is being used, the more because AI is kind of being trained. So it'll create an output and then it uses that output to train itself. So it's almost kind of creating this funnel neck where the outputs are starting to look more and more similar to each other, even though the technology is advancing. So this kind of weakens the uniqueness and market value to your artistic identity. So something good to keep in mind. Then the fact that a lot of these AI platforms, especially the prompt-based ones, are train their platforms without compensating the authors and the artists. So it's a lot of pirated work. This has come up a lot with pirated books, for example. So just something to keep in mind, because there are some lawsuits right now from authors who said, we don't want, our IP to be used to train your machine, because then that IP will show up in the outputs one way or another. So, you don't want to use something that a later court decision will say is actually not copyrightable because it was based on pirated work. And then income displacement, there are a lot of arguments about the fact that because AI generated work is kind of easier and quicker to create, it's going to put traditional artists in a difficult position. And copyright uncertainty, things are a little bit uncertain right now. We did kind of summarize today where the law is at, but I think you may have sensed that there is still a little bit of uncertainty left about what is copyrightable, what is not, and then as AI changes literally every single day, how does that change as things go on? So these are just good things to keep in the back of your mind as you use these tools. And we are coming to an end, and we know that each of you might have a very different workflow, as we mentioned earlier. So if you do feel like you need kind of a more personalized someone to sit down with and get more personalized advice with, or to get your work copyrighted, you can always give us a call. You can always kind of, visit our website. We have a lot of resources here. And I do believe we also offer very affordable flat fees for copywriting work. So that's also an option. But the free resources here are also good. And Joe, I want to ask if you have anything to add before we open the floor to any questions.
No, that was great. Nothing, we'd be happy to try to address questions in this area as best we can. We may not have the answers. But I think it'd be an interesting discussion nevertheless. We had a couple of questions in the chat, and then anybody feel free to jump in live here. But there was the last, I was trying to address questions as we went, as best I could. I'm sorry if I missed a couple. There is a question. The question is, if I'm working on behalf of a client, come up with an image for an ad campaign. So you've been hired by a client. Typically, in that sort of scenario, it depends on the contract, but it would be considered a work for hire. So you're authoring the content, but because they hired you to do the work, the client's going to own the copyright. All right. Should I be using their ChatGPT account when creating images, or should I be using a personal work ChatGPT account? What happens if they get sued for some reason because of the image copyright? Who has exposure? I think it depends on, honestly, that's probably driven more by your contract. I think that hopefully you would have indemnification clauses where if you're the author and you've used any sort of AI, that you're not personally liable for that. But it would depend on your contract, and that's, because you asked the question, Patrick, probably would be good to address that in your contract.
I wanted to add, oh, sorry.
Hopefully that answers it. Everybody might be stuck on mute. But Patrick, let me know if that did not address your question.
Thank you.
Then Faye, any thoughts you had?
I can't find the question in the chat, but I think you mentioned something about work for hire, and I just wanted to mention that if you are creating a work for hire, but the work you are creating you have to be cognizant about what level of AI you're using, because if your work is not copyrightable because you are using such extensive AI, then you are telling your client that you're giving them ownership of that work since it's a work made for hire, but there is no right to give because it was created by AI. So make sure that with this guidance that we gave you guys today, that there actually is an ownership right to give to your client.
That is a very good point. If they're expecting, like Faye said, if they're expecting to get a copyrightable work from you, and you've used generative AI to do that, they're not going to get what they probably thought they paid for.
Actually, I was scrolling back up and Chelsea had an interesting question. I don't think you answered it. Are you familiar with content credentials? Are there any scenarios that it makes more sense to formally copyright versus using something free like content credentials? Is using content credentials beneficial if paying for formal copyright is not accessible?
Chelsea, maybe you can
Yeah, I think you should
elaborate
be able to unmute.
a little bit on what you mean?
Yeah, so I'm familiar with content credentials, which I know Adobe and LinkedIn are partially behind, but it's really a movement to apply this like filter essentially to the images that you create digitally, and it kind of stamps it with authenticity and date stamps when it's created. And I think they're really starting early conversations around this. So I'm just kind of curious from your perspective and like a lawyer's perspective in
Got
general
it.
how we kind of see that fitting in because I personally feel like it could be a good cheaper alternative potentially, but just wondering if there's things I haven't thought of or since it's a newer thing, what it looks like as it intersects with copyright.
So yeah, it reminds me of like Bing Images, where you can filter out by commercial use or public, personal use. Sounds like that sort of thing. I think what it comes down to is what we talked about earlier, that you have a copyright in your work of authorship as soon as you fix it to tangible form. So you have a copyright. You can use the content credentials to stamp it and tells the public that you have a copyright, and you do. But you didn't go the extra mile of getting to federal registration, so you're going to forfeit some of those rights that we talked about earlier, like being able to file in federal court, like getting a right to recover your attorney's fees if you do have to bring a lawsuit, and then statutory damages, which can be often valuable in a copyright case. So I think, Chelsea, it can be effective to notify the public that they are not they don't have permission to use your work, um, but it just will lack the benefit of the federal registration. But I understand that you have to make decisions. We're you have to decide how you want to spend your resources, and you know copyrights, federal registrations for copyrights are relatively inexpensive, but they're not free. And if you generate a lot of works, it can add up quickly. And you're right; it could be more efficient just to notify the public, I have a copyright in this, and that's based on my content credential stamp.
Wanted to address. Oh wait, Chelsea, did you have a follow-up question on that?
No, that's great. Thank you so much for the info.
Okay. I wanted to address another question in the chat by Virginia.
Yeah.
She said, are there any differences for personal copyright versus corporate copywriting? And she said, we're feeling surprised that we could copyright a Midjourney image on behalf of clients. I think we misspoke. I think we like misstated this. So Midjourney images, if it's just a prompt that you entered and then there was an output, a Midjourney output, that is not copyrightable. So that was a good catch. But if you do generate Midjourney images and then you use those images to kind of create a creative arrangement, or say if you use elements of those Midjourney images within your work, then you can copyright that overall work. So including an element from Midjourney in your overall work will not prevent you from getting copyright in the overall work. But the raw Midjourney image itself, as of now, is not copyrightable.
We had
Thank you.
another
That's
one
really
just,
helpful.
oh, sorry. We had another one pop in by Mark that says, real quick on exposure, is there a limit to exposure on publishing something that may not be considered content created by an individual? Or is that a sliding scale based on the content, if that makes sense? Is there a case law out there? Or maybe Mark, do you want to hop on and elaborate a little bit?
Yeah, thank you. Yeah, I guess what I've seen, and I think the group probably have seen, is Disney's come out there and they were kind of going after Midjourney, and they kind of settled, I guess, right, based on they've agreed to work with each other on how their IP works. That is Disney. I'm wondering, as individuals, I've always heard people kind of shy away from using AI to create content because they're afraid of being sued for something. And then I'm like, well, if you're sued, like, what's the limitation of being sued for? Because it's still it's still there's got to be a limit to what damages or and I'm not the lawyer, right? So I'm just assuming or using words that make sound right, but there's got to be limited damages of what is being expected, I think, proven to court. Am I correct there, or like I need you guys to help me there?
Yeah,
Does that
Mark,
make sense?
that makes sense. I mean, it's what is your exposure? I mean, it can really depend, right? Because let's say you have, statutory damages, like I said, are between 750 and $30,000 per work. But that those statutory damages are really to help the copyright owner to get some recovery. The the exposure can be multiples of $30,000. If you have a very valuable movie, for example, that generates millions and millions of dollars in box office proceeds, and you ripped it off from somebody else, that's going to be your exposure. Now, so you kind of have to think about that. Now, if we're talking about um, things that Midjourney might generate, like images, I guess it's reasonable to think that your exposure is going to be limited, just because of the value of what you might be accused of having infringed. But I hesitate to say that there's limited exposure. Probably not what you wanted to hear, but the reality.
Thank you. Thank you so much. No, it's perfect.
You're welcome.
And then if we have time, there's one more from Carla that says, in a scenario where you use ChatGPT to generate copy for a client's brand voice, such as tagline or other body copy, or even using it for website design purely for the aspect of having copy written, who owns that? You as the designer or the client?
What do you mean about the copy? I don't know if I'm fully familiar with the graphic design terminology, if that's what that
Like
is.
copy like words and like
Copy of something?
yeah, text that you use on the website like they're and Carla,
Oh,
I'm putting words in your mouth, so please feel free to.
Hi, yeah, I was talking about writing like I think the tagline is the most evident thing, but also in a website you're usually looking at headlines and parts of body copy that might describe, depending on whatever, the client is selling, it might be a product, or it might be their own services, but in general, just generating that copy for the website, the written copy.
and would the client want to copyright that text, that copy?
I guess when you have a website, usually, there's like a little section at the bottom that will say, I don't know, copywritten by Colgate or whoever the brand is or whoever the client is. I'm not really sure if that goes into a different avenue of like copyright as a whole, but are they still able to put that when the copy was generated using ChatGPT?
So this will be a case by case scenario, and it goes back. I don't know if you remember the slide where I discussed de minimis versus appreciable portions of AI. So if it's kind of a small snippet of text that on its own, like if you would not be able to get a copyright just for that snippet of text alone, then that's considered um, de minimis, which you don't even have to mention. The full thing is it's copyrightable as part of the website. And then if it is a substantial creative text that if it had been authored by a human, you would be able to copyright, then that is considered appreciable. And you could still get a copyright protection for the entire website as it is. You would simply disclaim in your copyright application that portion. And I hope I'm understanding your question correctly.
Yeah, I think so. I think there's just, like we've been discussing a lot about who owns this and who owns that other portion and just wanting to make sure that me as a designer, I'm sure other people are careful with how we use these tools in relation to our clients and being paid for it. But yeah, I think overall I kind of understand that, you could copyright the website, but if it's heavily used and you're trying to go out for a copyright license, there might be some logistics there.
Yeah, copyright registration. So Carla, let's say, for example, what you did was you took the client's existing website, which described, like their About Us page, and you said to ChatGPT, generate me a 15-word tagline for this client. And ChatGPT came up with a 15-word tagline based on the About Us page from the website. That tagline would not be copyrightable because a non-human generated it. So it wouldn't be copyrightable by you because presumably it was a work for hire that you did for your client, and it wouldn't be copyrightable by your client either because the tagline was generated by a non-human, ChatGPT. Does that help?
Yeah, I do think that is more in line with the situation that I was kind of thinking about. But also in the same line, wondering if the client could ever run into any issues by using ChatGPT as your copywriter rather than hiring like a person.
The issue that, yes, so maybe ChatGPT no, but if you used, for example, one of the tools, and one of the tools that where the platform itself retained ownership of any output of the tool. So you have permission to use that via a license from the platform, but the platform owns the copyright. And I'm sort of making up facts here, but that permission may not be for commercial use. So if you've generated a tagline, for example, using a tool that retain ownership of the copyright, and then you gave that to your client. Now suddenly your client, that license didn't extend to your client because you've used it for commercial purposes, or other terms and conditions prevent that license from extending to your client. Now your client's using output from the tool commercially and potentially infringing the copyright of the tool. And then you have the other possibility where, and this probably wouldn't happen with a tagline, but if somehow, if you're using a visual, a tool that generated visual output, and somehow somebody else's copyrighted material ended up in the tool, and it learned on that copyrighted material, and that material showed up in the output of what you generated, you might have exposure that way as well. If that makes sense. So it's there's all sorts of problems that could happen when using these tools, but to some degree, we're focused on it tonight, right? So we have to keep it in perspective.
Thank you so much. That makes sense. Thank you.
You're welcome.
Anyone else? Just so everyone knows, in the chat, I did put the link to the Irwin IP's resource page that Faye referred to earlier. So if you guys want to like copy and paste that or click on it just so you have a tab open with it before this all closes out.
Thank you for doing that.
Yeah, of course. Are you kidding? Thank you. Faye and Joe, oh my goodness. Like this was so enlightening and so helpful, and you've shed so much light on the things that I know for myself have just been like so far over my head that I couldn't describe it. So like this, and I hope everyone else, I hope that this helped them too. I know a lot of people in the chat have been saying that you've really like shed some light on it and made it easy to understand. So thank you so much for taking your time to do this.
You're welcome, Cheryl, and thank you for we're grateful for the audience and having the opportunity to present to such a great group.
Awesome. Well, thank you all so much. And yeah, hopefully when it's warmer, we can maybe actually get in person together and do something IRL.
Yeah,
That would be great.
absolutely.
Awesome.
Thank you,
Well, thank
everyone.
you all.
All right. Thanks everyone for joining.
Have a good night.
Good night.